we're going to try and look at trends, current trends, and we're going to seek to give you a steer as to the direction in which things are going. Now, I want to start by looking at an international attempt to bring some sort of codification to the practice in how fraud issues should be dealt with in arbitration. And we quite recently had the Basel or BAL guidelines from the Basel Institute of Governance. And they specifically tried to set out certain international standards. And I want to start by asking Michael whether he thought that made a contribution and whether it will change the way things happen in arbitral hearings.
Thank you, Philip. Yes, two questions. I think that it's important in terms of raising the profile of the issue. Many people might say, well, it's an issue which doesn't really need its profile raised because it is a ubiquitous problem and it already has considerable prominence. But I think it is important in terms of identifying the problem, in terms of setting out red flags for the benefit of arbitrators, which is a sort of ready reference to check against if you think or suspect that there may be a fraudulent aspect to the matter which is being presented to you. Does it go beyond that and provide answers to these existing problems? That's where I think there is a greater question mark. Certainly they point up the dilemmas for arbitrators, but I get the impression, I don't really feel that I have a full answer or a full response provided by the guidelines, but that may of course be a product of the difficulty of the subject matter and not a fault of the guidelines themselves.
Thank you, Michael. I think it's the experience of all of us that fraud allegations and cases based on fraud in commercial litigation in the High Court in London has been a very common thing over recent years. And of course, international commercial arbitration is the principal way in which commercial disputes are resolved. And because much of it is private and confidential, we don't necessarily know what happens in private party commercial arbitrations. And we wouldn't see it unless it would be brought forward, for instance, in an English seated arbitration to the High Court under, for instance, Section 68 of the Arbitration Act. But there appears to be a strong trend, without being able to give any firm figures because of the privacy issue, a strong trend to fraud matters being raised. One area where we do see it, of course, is investor-state arbitrations, ICSID arbitrations, where, of course, the judgment is generally, or the award is generally published. Yep. And there are several very, very substantial cases that are dealt with fraud issues under the investor-state treaties. I'd like to take the principal issue, first of all, that's much discussed at the moment, which is the burden and standard, and how arbitral tribunals approach that in fraud cases, and whether their practice is any different. There are two recent, very substantial cases, Vail and BSG, and Nyko and Banga, the latter one's an ICSID case. They're several hundred pages long, some of the rulings, and so one has to scroll to the end to get the relevant parts. But Michael, do you feel there's any change in the way that the arbitral tribunals are approaching the burden and standard in fraud cases?
Yes, I think there's an ebb and flow here, which actually interestingly reflects an ebb and flow in domestic case law as well. If you go back to World Duty Free and Kenya, which was one of the early cases to raise fraud in this context, there what was spoken about was the need for clear and convincing evidence. And when you stand back from that form of wording, question arises, what is it? Is it approximating to the criminal standard of proof? Is it sort of halfway between criminal and civil? And if so, do we have a third standard of proof? Or is it a reformulation, perhaps a confusing reformulation of nothing other than the civil standard of proof? And I think after World Duty Free, it was taken to connote a higher standard than the ordinary civil balance of probability standard. Then one sees the row back, beginning, to my mind, in a case called Metaltech and Uzbekistan, where the scope of clear and convincing was questioned, as indeed in the NICO Resources and BAPEX and Petra Bangla. Then we get on to Vale and BSG Resources, where, as you rightly say, the tribunal and the court essentially says, well, no, it's a civil standard. But, and here one does have a clear parallel with domestic case law, there is an elasticity in the civil standard of proof. And it was put very clearly by Lord Hoffman in a case involving the Home Office and I think someone applying for asylum, Mr. Rahman. And Lord Hoffman said as follows: I feel bound to say that I think that, quote, a high civil balance of probabilities is an unfortunate mixed metaphor. The civil standard of proof always means more likely than not. But, he continues, some things are inherently more likely than others. It would need more cogent evidence to satisfy one that a creature seen walking in Regent's Park was more likely than not to have been a lioness to the same standard that it was an Alsatian. And in this basis, cogent evidence is generally required to satisfy a civil tribunal that a person has been fraudulent or behaved in some other reprehensible manner. So, in fact, the reason why I read that extensively was because he actually comes back and deals with the situation of fraud and behavior in a reprehensible manner, tests which we'll see and with which we're familiar. But it shows the elasticity of the civil burden of proof. Is it a lioness? Is it an Alsatian?
Right. Just moving on to the applicable law, obviously, if you have the seat and the law of the arbitration, you know what law you're going to apply to the arbitration. But in the case of fraud, you may be applying other systems of law. For instance, in order to determine whether bribery or corruption has taken place, the appropriate law may be the locus of the bribery or corruption. And so the tribunal is going to have to look possibly to several different systems of law in order to establish it. Now, that could lead to an interesting situation where, for instance, under the English Bribery Act, the UK Bribery Act, facilitation payments are out. They're clearly out. But under US bribery law, in some circumstances, facilitation payments are permitted. So you have a strange situation where a tribunal seated, for instance, in London, might be applying US law, which permitted an act that was illegal in London.
Absolutely. And this is where I feel a lot of sympathy with the drafters of the Basel guidelines, because you have to accommodate all of those possibilities: the law of the contract, the law of the seat, the law of the locus of the bribe which is being spoken about. You've also got to look at international norms. You may have to look at, you may well have to look at international conventions and treaties, whether that's the UN or the OECD, and there are various other regional guidelines which have been promulgated around the world. So this is a very, very complicated area. And again, to be fair to the drafters of the Basel guidelines, I think that really all they can do is point up what are the relevant considerations, because so much of this is going to be fact-specific, fact-dependent, and matching the particular fact facts up to the particular law and the particular treaties and convention, and also perhaps also transnational public policy.
All right. Well, I'm going to move on in a moment to get Herman's view on the civil law approach to this. But just before I do, I'm going to mention in passing one proud tradition of English law is that illegally obtained evidence is admissible, subject, of course, discretion of the court and various other matters, the civil courts. In the criminal courts, it's subject to a statutory safety valve. And we've recently seen a good example in the case of El Nahayan and Kent, where illegally obtained emails which had been hacked were admissible and were the very basis of the case. And exercising the court's discretion, they were permitted. I'm going to move straight away now to Herman and say, Herman, we've been talking here, Michael and I, largely based on English common law approach, the robust approach of the common law, and references by arbitral tribunals to the English High Court. How do you think that the civil law systems respond to those situations?
I would like to mention two aspects which have been discussed. First of all, the standards of which Michael talked. And I like the word elasticity. Of course, there are rules, and the rules is mainly that you need to have a full conviction of the judge about the situation of fraud which has been claimed. At the same time, you see a case law in the German Supreme Court, for instance, saying that once the period for reversal of an arbitration award has passed, the standard is stricter because you are under the rules of restitution claims. Whereas I also have seen a French case involving Alstom of 2019, where apparently the period of reversal had not yet expired, where they talked about circumstantial evidence being sufficient to raise fraud, where, for instance, the contract was not really performed, and similar instances. So I think the word elasticity for the standard of proof is correct, always considering also the period after the award, which is relevant. And of course, as far as admittance of evidence is concerned, the civil law rule is different. It's the exclusionary rule generally applying, so illegally obtained evidence is not admitted. Of course, with exceptions, particularly, of course, privacy rights determine, especially in Germany, where they are held up very strongly, that evidence is not admissible. At the same time, it looks at, is this the only evidence available, the one which was illegally obtained? Then courts tend to be more favorable to admitting the evidence. So it's basically a balance of the situation.
Thank you, Herman. We're going to move on now to look at the approach of the tribunal when fraud is raised in front of it for the first time. And the question then will arise as whether the tribunal has jurisdiction to determine that issue and whether the arbitration clause in the contract still holds good in those circumstances. That brings in the doctrine of separability. In England, certainly that question is ultimately subject to the courts if English law is the applicable law. Michael, would you like to say something about the approach of the tribunal to the raising of fraud and its competence?
Yes, certainly. I think that also one should perhaps begin by reminding ourselves of cases like Fiona Trust and Primalov, which established essentially that in a commercial arbitration context, if two business entities agree to determine their disputes through arbitration, then they would expect everything to be determined in arbitration, or at least as much as possible to be determined in arbitration. So whilst the courts exercise undoubtedly a supervisory jurisdiction, there is a clear imperative from the courts to place as much as possible back within the tribunal's power and remit. So to pick up on what you've just said about separability, even though an arbitration agreement will be very often within a much bigger substantive contract, the doctrine of separability means that that clause or those clauses which establish the agreement to arbitrate have a separate existence outside the scope of the substantive contract. And that enables the tribunal to have jurisdiction to resolve issues of their own jurisdiction. So if there's an allegation that a contract has been avoided by fraud, the tribunal has jurisdiction to adjudicate upon that question. It's, to use the German expression, Kompetenz, Kompetenz. They have competence to determine their own competence.
I just want to look now at a well-known case that you've already mentioned, World Duty Free and Kenya. Now, this is it's an ICSID case, first of all. It's an investor state case, so that's one reason why we know the details of it. It's a very substantial judgment, but if I summarize it this way, World Duty Free paid a bribe to the Kenyan president to get the permission to set up the duty-free facilities. The bribe was not in issue. And subsequent events occurred whereby World Duty Free, in effect, having been successful in the business, lost the business to the state, and they complained about discrimination. And the tribunal's decision, in short, focused a lot on the fact that the contract was originally illegal and therefore not enforceable. But if one looks at the pleadings in the case, World Duty Free were very careful to plead the case on a much wider basis. And they sought remedies in tort, in effect, and they sought restitution of their property, quite outside the contract. Now, the ruling spends a lot of time looking at the contract when that really shouldn't have been an issue. Now, at that time, what they said about the contract was in accordance with English law. We now, of course, have the Supreme Court's ruling in Patel and Mirza, and we now know that the fact that the essential fundamentals of a transaction were illegal, in that case, an insider dealing agreement, doesn't mean that you can't bring an action, not on the contract, because that's unenforceable, but for other forms of restitution, for instance, unjust enrichment in that case, and the money was indeed returned to the person who wanted to deal unlawfully as an insider. Now, my question is about those two very important, very substantial cases. Do you think, looking at Patel and Mirza, perhaps World Duty Free in Kenya might have been decided differently, or in the future, one could reasonably argue in that type of an arbitration that despite the illegality of the contract, some other remedy ought to be available?
Well, Philip, it's certainly more than the $64 million question, isn't it? And it's a very interesting point. I think ultimately I'm probably going to say it's going to depend on the particular facts of any subsequent case, but that's not a particularly helpful comment. So let me explain in a bit more detail how I come to that conclusion. You're absolutely right that in World Duty Free and Kenya, the fraud was found by the tribunal. The tribunals expressly recorded that Kenya had avoided the contract. The tribunal looked at international public policy, and they looked at the domestic law of both Kenya and England. And of course, one of the arbitral panel was the much missed late Johnny Vida. And Johnny knew his English law as well as his arbitration. And it's a classic exposition of the law as it then stood, starting off with Holman and Johnson, and really the law not lending any support at all to illegality and wrongdoing. And of course, in those days, Tinsley and Milligan was the leading case in this area. And that case essentially said, well, if your case relies on illegality, then you won't have a case. So it was textbook. But of course, as you rightly say, Patel and Mirza doesn't do anything on the contract side, but it does raise questions about restitution and unjust enrichment, and the fact that in that instance, Mr. Mirza had £620,000 of Mr. Patel's money and was hanging on to it, and there was no reason why he should. So Tilsley and Milligan was overruled in Patel and Mirza, and there's a much more nuanced approach. What is the underlying purpose of the prohibition? I'll come back to that. Are there any other public policy considerations? And is it a proportionate response? And I think it's really the first and third of those. What is the underlying purpose of a prohibition? Well, to stamp out fraud. So it may well be that that is a powerful indicator in favor of the loss staying where it, resting where it falls. In other words, no change to the outcome in world duty free. And also, if you're looking at a proportionate response, if you bribe the president of a country, if you bribe an official, then why is it not a situation of the devil taking the hindmost? So I think that there isn't a direct read across. There is certainly a much more nuanced analysis. There is a distinction between contract and restitution, but the result may be the same.
Before I bring Herman in to give us a civil law view on that, can I just say that I take a slightly different approach to Michael, in that I think the difficulty will be the public policy issue of bribing a public official. And I think that, because it's an ICSID case, there's always going to be a problem there. Although I do think that it's most unfair, and I think World Duty Free should have got its bribe back, but that's for another occasion. Herman, would you like to give us your view on that case and those circumstances?
Well, under civil law, especially under German law, the question is, what is the ground to seek restitution or unjust enrichment? Because the German law distinguishes between the causal link, like a purchase, a contract, and the transfer of the property in those cases. And there's a very basic decision of the German Federal Supreme Court saying that the transfer may not be affected, because the transfer is not affected by the fraud, because there's a consideration, and the fraud only relates to the underlying purchase. It was a bribe regarding newspapers which were returned to the owner and then sold off against the rules of the company, against the bribe. So the transfer was valid, so it was only unjust enrichment with shorter limitation periods and so forth. So you need to be very careful about on what basis you are seeking the return.
Thank you, Herman. Michael, we're going to move on now and look at challenges to how fraud was dealt with in the tribunal under Section 68 of the Arbitration Act. Now, there are a raft of cases on Section 68, and we're just having a whistle-stop visit here. I'll just say the principles were very helpfully set out a couple of months ago by the Privy Council in the Bahamian case, RAV Bahamas and Therapy. But would you like to just say something about the prospects of interfering with what happened below in a Section 68 application where fraud is the issue?
Yes, certainly. I think the purpose of Section 68 is to provide really an exhaustive guide to challenges in the English courts, challenges to arbitration awards. And the guiding light, I think, really is the two-pronged aspect, that what the court is looking at is whether there has been serious irregularity, but also whether there has been substantial injustice. Now, when you're talking about fraud, serious irregularity more or less proves itself, and there have been cases which say that. The more interesting area, and please feel free to ask me supplementary questions in elaboration of this, is the extent to which fraud does or does not, depending on particular circumstances, wreak an a substantial injustice on particular facts. And I think it's that twofold test which is very important to bear in mind. Simply because there's fraud there doesn't necessarily mean that Section 68 has been satisfied.
Herman, I think there's a number of substantial cases in Germany and France dealing with an appeal to the court about what happened in the arbitral tribunal below.
Yes, indeed, indeed, and it's very true what Michael said. Meaning there was fraud involved does not mean it is necessarily set aside. There's one case where the period for reversal was expired, and the German Supreme Court took refuge, so to speak, to a general section 8626, which is about damages for immorality, and this helped to resolve to reverse the award. In this case, it was a domestic arbitration, and we need to distinguish between domestic and international arbitrations. The same applies in France, where, of course, we had the very famous affaire Tapie, where Mr. Tapie was first losing in the French courts, and then with some help, an arbitration agreement was arranged, and then the bank who was seeking the money was sued for undue support, and therefore the French Supreme Court had to decide about the fact that the arbitrator in this case was allegedly colluding with one of the parties. So it was a case which was very much damaging the reputation at the time of the French legal arbitration system, but helped the court decisions, especially of the Cour de Cassation of the Supreme Court, helped a lot. So we have these different situations, and we had a German case of the Supreme Court about an international arbitration where it was raised within the period of reversal, and therefore the situation was easier to handle.
Thank you. Michael, I'm just going to pick up one other type of challenge in the High Court, which we see under Section 9, the Arbitration Act. In a remarkable number of arbitrations where fraud becomes an issue, and I'm talking about London-seated arbitrations now, we find local proceedings. That's the locus of the alleged fraud or bribe springing up. Yes. And there's a couple of well-known cases involving Nigeria and Mozambique, where those local proceedings purport to stay or interfere with or override the London-seated arbitral proceedings. And the High Court's quite good at dealing with those, isn't it?
Yes, it is. And I think the two cases that you have in mind exemplify the point. Because the very recent case involving Mozambique and Credit Suisse concerned whether, well, obviously Section 9 is an application to stay court proceedings in favor of arbitration. And in the Mozambique case, it arose out of loans and guarantees which were connected to supply contracts. And it was claimed that bribery and corruption in connection with the loans. Now, the arbitration agreement in the supply contracts, the question which arose was, is that wide enough to encompass bribery issues in the loans and guarantees? At first instance, it was held not to be the case, but on appeal, the Court of Appeal stayed the proceedings on the basis of a sufficient connection, and therefore the requirements of Section 9 of the Arbitration Act being satisfied. Now, that is a very interesting case because it demonstrates the whole court approach, again, to being pro-arbitration and moving things into an arbitral context where possible. Of course, one needs to dig a little bit more deeper into that because of parties to the arbitration, but let's leave that on one side for present purposes. The other case, or I think it's more than one case, it relates to really anti-suit injunctions, where you have an arbitration agreement, but a party has started proceedings in another jurisdiction. The particular example you've given is Nigeria. And the question then is whether an anti-suit injunction should be granted in this jurisdiction in support of the arbitration. And as long as there are good grounds for the arbitration agreement being valid, and if there's no reason for the courts in another jurisdiction to be troubled, and English jurisdiction, therefore the English courts are the supervising courts, then here, again, in support of arbitration, the English courts will have little compunction once those requirements have been satisfied, and they're fairly easy to satisfy. The English courts will have little compunction in granting an anti-suit injunction, a worldwide anti-suit injunction. Obviously, there may be practical difficulties in relation to enforcement, but the injunction is there and is in place in support of the arbitration.
Thank you. Herman, what's the civil law experience of anti-suit injunctions?
Very little. The first enter-suit injunction, or enter-suit injunction in that case, was in 2019 by the local district court in Munich, upheld by the appeals court. So it's quite unfamiliar for two reasons. The first one is a basic principle that other parties should not be compelled, not restricted in conducting court proceedings. And the other one, that it would be an imposition onto the other courts in the realm of the Brussels I regulations. Now, this, of course, now does not apply anymore to England, and therefore we may see much more inter-suit injunctions in European courts, continental European courts, relating to common law cases.
Thank you. I think today we probably don't have time to deal with fraud in enforcement in arbitral proceedings, other than to say that PNID in Nigeria makes it clear that if you discover the fraud 10 years later, it's not too late. And that's an encouragement to everyone. But I want to go on now and deal with our final substantive topic, which is confidentiality, privacy, and reporting obligations in a case where fraud is brought before a tribunal or possibly occurs in the course of the arbitral tribunal. Now, the principles of privacy, they arise from the arbitral agreement, from the contract, and under English law, that's an implied term, not, of course, in an ICSID or investor state arbitration, where, for all sorts of reasons, including public policy, the arbitral awards are usually published. But confidentiality is wider. And there are a number of problems, aren't there, Michael, about the obligations of the parties, the arbitrators, witnesses, expert witnesses, where fraud, serious fraud, where there's a public interest and the interests of justice may compel some sort of disclosure to a relevant authority. So what's the approach, first of all, in English law to disclosure and confidentiality?
Going back to the Basel guidelines, there's a discussion there as to whether there is a duty to disclose on an arbitrator or whether there is simply a right of disclosure and that therefore there's a voluntary element to it. My view is that the position in English law is absolutely clear. It must be in the interests of justice, it must be in the public interest for disclosure of fraudulent conduct to be disclosed and brought to the attention of the relevant authorities. I would regard it as a duty rather than a sort of permissive right.
Certainly, so far as the English High Court's concerned, if one was in doubt, you could go to the English High Court for permission. It's also an exception in English law to establish or protect your own legal rights. But again, one might go to court as a precautionary matter for permission. Yep. And as you say, the interests of justice are almost certainly going to be engaged where fraud is concerned. I think the leading case is probably Westwood Shipping, establishing those principles. Herman, tell us about the civil law approach to disclosing fraud which is revealed to the arbitral tribunal.
Let me first say that there are different statutory rules in various countries, whether at all arbitration is confidential. And this has a big impact on the drafting of the arbitration agreement, or looking closer at the institution which one has chosen to see whether it provides for confidentiality. For instance, the Spanish code imposes a duty of confidentiality, and the same in the French law for domestic arbitration. The Swiss law is open, and as is the German law. And there's been a discussion whether you have an implied term because you choose arbitration, but it has really not been, I wouldn't rely on this, it has really not been generally accepted. As far as the duty of the arbitrator to disclose, I think we are pretty much in line with what you have expressed for English law, because if an arbitrator discovers a fraud, that would be reportable despite the confidentiality of the proceedings.
Yeah, and I'd actually like to pick up on what
Yes.
Herman was saying about the question of confidentiality with regard to how it's dealt with in different jurisdictions. If it's a creature of contract and it's therefore an implied term, then it would be considered according to the law of the arbitration agreement. But if it's a statutory obligation, then that statute is likely to be the statute of the seat of the arbitration. So again, one has this interplay of different laws in operation, to which you can add a further element, namely some institutional rules cover confidentiality, other institutional rules don't. As Herman was saying, even within continental Europe, without looking further afield, there are different views and different approaches adopted by different jurisdictions. So in terms of practicalities, I think that this should be dealt with, if not expressly in the arbitration agreement, certainly in procedural order number 1 or case management directions, or if not in those instances, at the outset of the substantive hearing of the arbitration.
And Michael,
Let me perhaps revert to just briefly to the Tapi case, because there the public prosecutor disclosed information from the public prosecution to the court, which was handling the reversal of the arbitral award, to help actually overturn and solve the fraud. And there was a challenge to this, because it's a secret of the instruction of the prosecution. But then it was argued that this only applied to the prosecution itself, not towards third parties and the judicial system. It was quite an interesting debate going on in that regard. Sorry.
Oh, thank you, Herman. Taking Michael's point about this should be dealt with in the directions. Of course, we've been talking about the parties and the arbitrator, but one mustn't forget the witnesses, and in particular the expert witnesses. And confidentiality should be dealt with there.
Yeah, absolutely. And you may even draw a distinction, or you may need to consider separately the position of expert witnesses from witnesses of fact. Because an expert witness, you may say, well, it's an implied term of their retainer as an expert that they meet and satisfy all confidentiality obligations inherent in the arbitration. That isn't necessarily so apparent when you have witnesses of fact. And therefore, I think that you can legitimately draw a distinction between those two.
I'm going, just before we turn now to see if there are any questions, I'm going to invite you both to make any final comments and to comment on this. Do you see a particular trend? We've seen the way commercial fraud litigation has developed in London, the way English law and procedure has developed in order to accommodate it on an international basis. Do you see any trends in how arbitral law is developing? And is there a real substantive difference between the common law approach and the civil law approach in your practical experience as you've seen in arbitral tribunals? And Michael, if you'd like to go first.
Well, I think there's a trend towards, there's certainly a trend towards awareness of fraud in arbitration. There's a trend towards transparency. Certainly, you mentioned the Westwood case, the need to bear in mind the interests of justice in this whole context is, I think, very important. But we should also be aware of the differences. Perhaps it's too stark to talk simply about the differences between common law and civil law, because as we've just been seeing in terms of the treatment of confidentiality, it varies amongst civil law jurisdictions. But nonetheless, I think that there is a well-recognized there are well-recognized cultural issues in international commercial arbitration. They may be geographic cultural issues. They may be issues which arise between the common law and the civil law. There is an enormous amount to unpack there, but also, of course, one must remember that the essence of international arbitration is to synthesize all of these strands and bring them together in a way which provides a business answer to a commercial dispute. And that, I think, is the touchstone for how these quite knotty and detailed issues should be addressed.
Thanks, Michael. Herman, would you like to make some concluding remarks on those topics?
Yeah, there may be, systematic differences between the common and civil law, especially when we saw the admissibility of evidence obtained in fraud. But in the end, through the exceptions and through the practicality which arbitration has, the practicality to solve business issues, we see very much an alignment between the two forms. I think the cultural issues remain. The transparency is a very dominant factor in relation to fraud. We see more cases with fraud being raised. We also see more in-depth investigations bringing fraud to light, and therefore I see a convergence in this area, which is very much governed by transparency and, of course, by the various typical seats of arbitration also being party and arbitration and solution friendly.
Thank you, Herman. Well, we've got some questions, so I'm going to move on now and deal with the first one of those. And it is asked, to prevent enforcement of a foreign arbitration award, what is the main difference of the respective tests under English law as compared with civil law jurisdictions regarding the sufficiency of evidence necessary to show fraud so that enforcement is denied on the basis of fraud? Would a criminal fraud conviction in a foreign jurisdiction be sufficient? Would an admission of fraudulent behavior in administrative proceedings in a foreign jurisdiction be sufficient? So I think that's something you both have thought about and certainly spoken to me about. Michael, would you like to go first on that?
Yes, I'm very happy to go first. And I think we need to unpack some of the questions which are set out here. And let's begin with one in the middle. Would a criminal fraud conviction in a foreign jurisdiction be sufficient? Well, I think the answer to that, again, is it depends. One might at first blush say, well, of course, if someone's been convicted of fraud, then that is plainly going to go to public policy considerations under Section 103 of the Arbitration Act here. But think about it for a minute, because there are quite a number of jurisdictions around the world where a criminal fraud conviction may be secured against someone who is causing considerable difficulties to the state in question, where the courts are perhaps lacking the independence and rigor that we would expect, and where a criminal fraud conviction in those circumstances would need to be investigated really very carefully indeed. Is it a genuine conviction, or is it a conviction, if you like, of convenience?
But Michael, in English law, Michael, you wouldn't you wouldn't need a conviction. For instance, IMPD, that very substantial case, though no one had been convicted there, but I think Mr. Justice Cranston had before him evidence which, I don't know if you like the expression good arguable case, but he said it was not his function to determine those facts, but he said that there was a basic case there. So you don't need a conviction in English law,
No,
do you?
you don't need a conviction, but I'm simply, really what I'm putting is the flip side of it, saying that a conviction may not, depending on the circumstances, cross the threshold. But you're absolutely right. What the court will be looking for is some form of reprehensible or unconscionable conduct, which has contributed substantially to the obtaining of the award. And that essentially is the test. You do not need to have a conviction. In the circumstance, again, everything's going to be fact specific and fact dependent. But in the Process and Industrial Developments case, the P&ID Nigerian case, there was really very substantial evidence
Untested,
of the
Michael.
potentiality of fraud.
Evidence that was untested, Michael. Anyway, I want to move to Herman now, because I think that the civil law approach, or at least the German approach, is rather different, isn't it, Herman?
Well, first of all, the question supposes, I would answer the question in the way that the fraud has not been at all addressed in the arbitration, because that makes the question more interesting. If it has been, then it's a question of in which way it has been handled. But the general, indeed, because we were saying conviction is not necessary. Conviction is necessary once the 3-month period in Germany, other countries may have different periods, has expired for the reversal. So in that case, the German Supreme Court really sent a case back to the appeals court to take evidence whether the criminal act was completed or not. There was reason to convict, not a conviction itself, but also the civil court could test whether could take evidence whether the criminal behavior completed a criminal act. So that depends also on the stage of when the setting aside or the reversal is being sought. Yeah. That's a very big difference in two cases which the German Supreme Court has decided. And then the burden of proof is also different, whether it is an international or a domestic arbitration, as we said earlier.
Yeah, and I'd just like to come in agreement with what Herman was saying, and particularly raise or refer to another English case, the Westacre Investments and Jugo Import, where one of the tests which was set out in the Westacre case was the evidence of fraud available at the time of the tribunal hearing, or has it only come to light subsequently? And if it was available at the time of the tribunal, why wasn't it taken fairly and squarely then? So that raises a really very high hurdle for you to take that sort of point a long time after the event, if the evidence had been available earlier. The second element of Westacre is that there has to be a prima facie case of fraud sufficient to overcome the extreme caution that a court will adopt in approaching this sort of issue.
Thank you. Now we've got a further question I'm going to move on to now. This one comes somewhat from left field, and so you should be ready for it. Could written correspondence, which is subject to legal professional privilege, be used to prove fraud in relation to an award? How to challenge the privilege? Michael, would you like to have first tip at that?
Yeah, I'd like to answer a question with another question. How have you found out about the written correspondence which is subject to legal professional privilege? Because there is an assumption underpinning this question. There's an assumption underpinning this question that it's the other side, the side which would not be claiming legal professional privilege, has found out about it. So let's assume that party B has found out that in correspondence covered by legal professional privilege, party A has disclosed fraudulent conduct. Well, in those circumstances, I think we're back to possibly illegally obtained evidence, or perhaps accidentally obtained evidence. And there you have a balance. And I think, again, in the interests of justice, the English courts would be very clear and would want to root out any wrongdoing. So I think that the interest of justice would trump privilege once the breach had occurred.
As you say, Michael, that would be very heavily fact dependent, wouldn't it? Herman, have you got any thoughts on that particular question?
Well, we said earlier that illegally obtained evidence is in principle not admissible. So it also depends on whether there is other evidence in the same direction as this correspondence, which is subject to privilege. But we also should be careful, because the rules of privilege under the common law jurisdictions and civil law may not be the same. I think this is important to keep in mind, because the experience shows that often the common law principles are stricter than the civil law ones. So it's also very important which law governs privilege, and that's probably the law of the seat of the arbitration.
Yeah. Actually, that's a very interesting point, Herman, because if you look at the Akzo Nobel litigation in front of the European Court, and the question whether privilege extends to general counsel in the employ of one of the parties, you'll come to completely different views according to whether you're applying certain continental legal systems approach and the English legal system approach, which would extend legal professional privilege to communications between a general counsel and other people within the firm. So you're absolutely right. There's a risk of competing ethical and moral obligations, double deontology as it's known. It's a very difficult area. How would you challenge the privilege, which is the other question asked here? Then I think the clear way would be to write to the other side, first of all, because it would be their privilege, but you would be drawing attention to the fact that you knew there was evidence of wrongdoing. That's likely to produce a fairly impressive response from the other side, I would have thought. And you would then make an application to court and let the court determine it. But another aspect, just going back to confidentiality, what about different corporate entities within an umbrella grouping? So if one subsidiary in a conglomerate is a defendant or a party to an arbitration, where does the privilege stop in relation to that subsidiary or element of the conglomerate sharing information and thereby breaching confidences with its parent company, with a sister company? There are all sorts of interesting corporate issues associated with confidentiality, even at that level.
I think it's clearly established in English law, at least, that if you show a parent or a subsidiary company material that you've obtained subject to undertakings or obligations of confidentiality, that's impermissible and unlawful.
I agree.
Clear authority to that effect.
I agree, but
and it's happened quite a lot.
Exactly. Do the companies appreciate that? And do general counsel advising appreciate that? I agree with you totally, Philip. But it's a trap for the unwary.
Yeah, and one way to challenge the privilege is also, I mean, to involve the professional bodies. That can be burdensome, but it's more indirect, of course.
Right, well, there are no more questions, so that brings us to the end of this webinar. Thank you both very much indeed. I've enjoyed this. I hope you have, and I hope everyone attending's enjoyed. Just to remind everyone that we will publish a list of all the cases we've mentioned, and we will make available a recording of this that you'll be able to download at some future stage. So with my thanks once again to my two panelists, and thank you to everyone for attending, we're going to close this session.